or 60% or 59% or whatever. And so what I guess I'm a little concerned about in your argument is the idea that a candidate who wins and who wins by some margin is harmed by a regulation of this nature because of the potential decrease in his margin of victory. I don't understand the harm that necessarily comes from that.
So if you start with the premise that every candidate would prefer to win 60% rather than 51%, and then you challenge—
Why do we start with preference? That's what I'm saying, that the relevant metric for standing is harm. So yes, fine, you might be disappointed, but that's usually not what we look at when we're determining whether or not someone is actually harmed.
Well, I would say that if a law improperly denies somebody their preference, that is a harm. But in all events, I don't think you need to make it that abstract. If the abstraction is what's bothering you, he alleges in his declaration that that is accompanied by reputational and financial harms as well.
Isn't that speculative? I mean, couldn't we also speculate that a candidate who decreases the margin of error, or excuse me, the margin of victory, who wins by a smaller amount, people would actually want to contribute more the next time, as opposed to them not having contributors? I don't necessarily see a financial harm that comes from a smaller margin of victory.
Well, on this, I mean, I think this is the kind of issue that at this stage of the case, where you have a complaint and you have declaration, you haven't had any evidence. If the other side wants to come in and put on an expert that says, actually, Congressman Bost, who's run successfully in Illinois like a dozen times, doesn't know what he's talking about.
No, I'm saying it's your burden. You're the petitioner, and you have to establish standing. You're the plaintiff. So you have to show that you have a non-speculative risk of harm here. And I just don't understand how saying, well, I would prefer to win by more actually counts, especially when you're winning by, more or less is sort of speculative in this context.
Well, with respect, I think if you're going to allow people to challenge election rules at the beginning of the election, which I actually think is something that the standing doctrine should not get in the way of, because it avoids having these disputes litigated at the worst possible times, you're going to have to allow some room for a little bit of speculation. I mean, because the election hasn't happened yet. But the way that this court's cases have generally dealt with that is you have to show that there's a substantial risk of something. And here, there's no question in my mind that at this stage of the litigation, between the allegations and the declarations, he's done enough for the motion to dismiss stage. Again, we all know that standing law has to be sort of addressed at the level of substantiality for every stage of the litigation. And so if they want to continue to contest this, I suppose at the summary judgment stage, we could have competing experts on some of this stuff. But frankly, I think that is a pretty good advertisement for a broader, simpler rule that simply says candidates have standing to challenge the rules that govern the election.
If it were